Good afternoon, everyone. A very warm welcome to all of you who have tuned in to this week's webinar with us. We hope you are doing well and keeping your spirits up at home as we move into the fourth phase of our MCO. My name is Hui Lin and I am a partner with the Corporate Commercial Practice here at ZICO. I will be the moderator for today's webinar. The topic of our webinar today is a legal health check for your transactions. Now, I'm sure many of you are going through the contracts that you have signed to find out if any of the obligations can be suspended. At the end of this webinar, we hope that you will have a better understanding of how to utilize these clauses you have in your existing agreements and what are the clauses that you should not live without when entering into an agreement. Our agenda for the day, this webinar is separated into two parts. On the first part, we have Mr. Jay Kuhan, or Kuhan, a partner from our litigation practice group, and Wui Hong, a partner from our corporate commercial practice group. They will discuss if, number one, you can terminate or suspend a contract which is affected by the MCO through the use of force majeure clauses, frustration, and material adverse change clauses. Together, we will then examine a wide range of contracts from tenancies to equity and debt documentation. On the second part, Stephanie and Ida Hani, who are both our corporate commercial partners, will examine the use of representations, warranties, and indemnities as a tool, together with the measures that you can take, whether you are a buyer or seller in a transaction, the use of W&I insurance in a transaction, and how to future-proof your transactions. We would like to remind all of you that you can ask questions throughout the webinar by typing them into the Q&A box. Due to time constraints, we may not be able to answer all of these questions immediately, but we will respond to you with a follow-up email after this webinar or to link you with one of the lawyers who are experts in the field. So please leave your name and email address when you type your questions to us. Now, without further ado, I would like to pass the mic to Kuhan, who will address the issue of whether contracts affected by the MCO can be delayed or terminated.
Hi, good afternoon. Ladies and gentlemen, good afternoon. My name is Kuhan, and I'll be taking you through this topic of FM clauses and frustration of contract. So it's a three-parter, and on the first part, I'll be covering basically on business being built on contracts. Contracts carry obligations to parties. So can a pandemic like COVID-19 be the reason or excuse to suspend those obligations with minimal or zero liability, or justify ending that contract without either party having any legal claims against the other? So an FM clause or force majeure clause is the answer, but it's important to note that the FM clause must be an express term in your contract in order for you to rely on it. In part 2, the question is, do MCO regulations constitute force majeure events in leases and tenancies? Rental can constitute a big part of the overheads of a business. If a business cannot run from its rented space or has limited use of it due to the MCO regulations in place, does that amount to a FM event that frees the tenant or lessee from their rental payment obligations? And in part 3, which is on the frustration of contract, in the absence of a FM clause in the contract, can one claim that the contract is impossible to perform due to the MCO being enforced, thus freeing that party from their contractual obligations as the contract is deemed to be frustrated? Right, could I have the next slide, please? So let me begin by giving you a quick explanation of what is force majeure, or FM for short. FM generally refers to unforeseeable events or circumstances that hinder or prevent someone from performing a contract. There are some elements to consider in order to successfully rely on FM. Next slide, please. In order to establish that a contract has a valid FM clause, the party relying on it has to show that there are contractual provisions in that nature. What constitutes a FM event will depend on precise wordings. Some FM clauses carry specific terms and actually mention events such as quarantine, epidemic, pandemic, or embargo. Some other FM clauses carry general terms interspersed with specific terms. These could be words such as acts of God, restraint of government, any other causes beyond the reasonable control of the party claiming an event of FM. Second point needed to establish a FM clause is that the delay or disruption in fulfilling the contractual obligations were not reasonably foreseeable. While an epidemic could be reasonably foreseen from this COVID-19 virus outbreak, the current unprecedented level of disruption is unforeseeable. Next slide, please. The third point is cautionary. Be careful not to wrongly declare an FM event. The counterparty could construe this as a repudiatory breach, meaning it has a right to claim for damages for the breach. The final point has three parts to it. The party relying on the clause must take reasonable steps to mitigate the effects of delay or failure to perform. Failure to do so may undermine your ability to rely on the clause. Check if there are specific notification requirements that apply to the FM events. What is the time period to notify and the mode as to how the other party is to be notified. Such requirements must be strictly adhered to. And finally, depending on how the clause is worded, some may provide for termination of the contract and some may also provide for temporary suspension of performance of the contractual obligations, waiver of non-performance penalties, or method of apportioning losses between the parties. Consider if it is better to renegotiate on a solution to deal with the disruption rather than ending the contract. Next slide, please. I'm going into part 2. How do the MCO regulations affect the rentals due to be paid by tenants? Next slide again, please. A study of Regulation 5, Sub-Regulation 1 of the Prevention and Control of Infectious Diseases Regulations 2020 allows for any premises providing essential services to operate with limited number of personnel and patrons within the premises at any given time. Hence, commercial tenancies and leases providing essential services such as banking, healthcare, and food supply are permitted to operate their businesses. Not so for non-essential services, which have to remain closed during the MCO and very likely continue to bear the burden of paying their rental to the landlord. Next slide, please. If there is a force majeure clause stipulated in the lease or tenancy, that clause has to be studied to ascertain the allocation of risk between the landlord and the tenant. Force majeure clauses are intended to include risk beyond the reasonable contract of the parties, which frees both parties from their liabilities and obligations when a supervening event takes place. So what is the outcome of claiming force majeure? That will be clearly stipulated in the rental agreement, as it may vary from one agreement to another. In some, it could be the reduction of rental for the period affected by the supervening event. In other rental agreements, it could be the deferment of payment of rental. In some contracts, the triggering of the FM clause may bring the rental agreement to an end. This may be the inevitable outcome in some instances. Next slide, please. If there is no force majeure clause stipulated in the tenancy or lease, the bad news is that it can be construed the party seeking the pandemic to be an MCO to be construed as a force majeure event cannot do so. An old Supreme Court decision still referred to till this day, Finma Consultants Private Limited versus Development and Commercial Bank Berhad, states that if a party makes an unqualified or absolute promise, he accepts the risk of performance of that promise becoming impossible. He will not be discharged from liability if performance becomes impossible through no fault of its own. So that brings us to part 3. And that's the next slide, please. How about using the doctrine of frustration of contract to discharge one's contractual obligations if there isn't a force majeure clause? In Malaysia, in order to discharge by frustration to be successful, one must show that the event or change in circumstances was not self-induced and renders the performance of the contract radically different from what was originally undertaken, to the extent that the court must find it unjust to enforce the original promise. The doctrine of frustration of contract is codified in the Contracts Act of 1950, specifically in Section 57, and it reads as follows: an agreement to do an impossible act in itself is void, and a contract to do an act which after the contract is made becomes impossible to perform will be considered as void. Next slide, please. The application of Section 57 of the Contracts Act 1950 is seen in a Court of Appeal case called One Aikmore Kuala Lumpur Sedang Berhad and another versus Selangor Properties Berhad. Now let's consider our situation of an affected tenant in attempting to fulfill the 3 elements laid out by this case. A, The event, that is the MCO under the regulations, upon which the tenant relies as having frustrated a tenancy agreement, must have been one for which no provision has been made in the tenancy agreement. Now, in our scenario, this is fulfilled as there is no FM clause in the tenancy agreement. B, the event relied upon by the tenant must be one for which it is not responsible. Again, this is fulfilled as the tenant is not responsible for either the pandemic or the ensuing MCO. And C, the event which is said to discharge the promise, that is the tenant's covenant to pay rental in full to the landlord, must be such that it renders it radically different from that which was undertaken by the tenancy agreement. This too is fulfilled as the tenant is unable to operate their business from the premise they are paying rental for. This brings us to the next slide. This point has to be tempered by the federal court decision in Public Forest Industries in Berhad and another versus Lin Wei Chi and another, which held that a contract does not become frustrated merely because it becomes difficult to perform. The inability of the tenant to run its business, or if the tenant is unable to pay its debt, it cannot be considered impossible to perform as it is not frustration. So ladies and gentlemen, guided by the statutory provisions of the Contracts Act 1950 and the legal precedents set by the Malaysian courts, a tenant will find it an uphill battle in proving to the court that the tenancy agreement may be frustrated due to the reason that it will face financial difficulty in coming up with a monthly rental. Even if a tenant is able to frustrate the tenancy agreement, the effect of frustration is that the tenancy agreement shall be rendered void, and this is not the intended effect for having reduced or deferred rental throughout the period of the MCO. With that, ladies and gentlemen, I thank you for your kind attention and hand you back to our moderator, Huilin.
Thanks, Guhan. For the benefit of the additional attendees who have just joined us, I just wanted to recap what's happening today. Currently, we are discussing the use of force majeure clauses, the concept of frustration, and material adverse change clauses. At the second part of the webinar, we have Stephanie and Irahani who will talk to us about the use of reps, warranties, and indemnities, and how to future-proof your transactions. Now, we also want to remind all of you that you can ask questions throughout the webinar by typing them into the Q&A box. Due to time constraints, we may not be able to answer all of these questions, but if you leave us with your name and email address, we will follow up with an email after this. Now back to the presentation. We have heard from Kuhan that there are a lot of issues about tenancies, and this is being widely discussed out there right now. But actually, FM clauses are fairly common across a wide range of documents. So we now move on to the second part of the first section, where Wei Hong will share his thoughts on various force majeure clauses and how you can contrast this with another type of similar clause called the material adverse change clause.
All right, thanks, Huilin, and good afternoon, everyone. Before I start, if you find my voice to be a bit soft, my device cannot go louder, so you may have to adjust your volume. I apologize for this. Now, FM clauses, as Huilin correctly pointed out, it does exist in many types of contracts. I intend to discuss them from a drafting perspective so that perhaps you can use some of the takeaway points to see if you need to review or renegotiate them. Now, from a drafting perspective, there are several components that are required for an FM clause. And these components are applicable across all forms of contracts. You will see on the slide that I have set out some examples of the contracts that I will be using as illustration. It could be that the sample that I'm using will have an FM clause that differs from the same kind of contract that you have in your situation. So please bear that in mind. I should also caveat that we are discussing this in the context of Malaysian law. So some of the contracts could be subject to governing law of other jurisdictions, where some of the components that we are discussing here may not be required. So if you may have chanced across the Starbees article that Kuhan and myself wrote, in Indonesia, Philippines, Thailand, and Vietnam, there is no need for an express provision for an affected party to seek relief through force majeure as it is by way of operation of law. So that takes us to the next slide. Now, for FM clauses, we typically consider 6 components that needs to be drafted. The first and all important is what is the triggering event. Now, some contracts are written in a way that it refers to examples of events such as epidemic, natural catastrophe, riots, etc. But the operative word is that the events must be beyond the control of the parties, causing them not to be able to fulfill their obligations. Now, this is seen in, for example, the bank facility agreement sample that we had. The emphasis here is that while the event may be triggered, the key is whether the party has lost control of the situation. Now, this is to be contrasted with other contracts where the trigger is just a set of finite events followed by the consequence of there either being a delay or impossibility in performing the obligation. This could be seen in a sample construction contract. Here, it is entirely possible that if the events are not found in the finite list, even if there are other events causing the delay, one cannot avail himself to the FM clause. So the lesson here is to clearly review if the force majeure is triggered by events plus consequence, or it is purely based on consequence. It's not to say which one is fairer over the other. Construction contracts for infrastructure concessions, such as LRT projects, may be worded more rigidly because tax money is involved if there is a delay, right? So in a sense, there is a risk allocation factor at play here. And therefore, it's subject to negotiation. Now, the second element to consider is who is the FM clause benefiting? In the case of the facility agreement, the FM clause helps the bank. There is no FM clause for the borrower. So that is why regulatory intervention is important with the 6 months moratorium. Of course, the question then becomes what happens after the 6 months, there is still difficulty. And I think this is where the borrower and the bank will need to start discussing loan restructuring, right? The third element to consider is what is the intended consequence of triggering the FM clause. So as Kuhan has already mentioned, sometimes it could be a delay, sometimes it could be termination. So the consequences do vary. Hence, parties should consider carefully what is your current FM clause like, and especially if you're not looking for termination and you don't have a delay type of outcome, then perhaps it may be prudent to renegotiate upfront for a possible postponement of your obligation, right? The fourth element is notice. Now, almost all contracts would have a boilerplate notification clause. But because the notification clauses are worded generally, most would think of using it only when there is a default situation or perhaps when certain contact particulars have changed, and not specifically when the force majeure takes place. But nevertheless, this is a requirement. So whether it is expressed contractually or otherwise, if you plan to use your FM clause, you do have to provide notice. Yeah. The fifth element is the duty to mitigate. Now, for the bank's facility agreement, there is no express duty to mitigate. The sample ISDA master agreement, which in this case is equity derivatives instrument, there is a reference for parties having taken reasonable effort to overcome the situation that is beyond the control of the party. In our sample construction contract, there is an express duty, and I quote, to diligently mitigate a force majeure event, right? So the question here is mitigation a legal requirement? Kuhan has said so. It is part of law. So even if your contract is silent, you do have a duty to mitigate. Now, that is why in the bank's case, you will find that at the start of the MCO, the banks have attempted to continue their documentation process. perhaps to show that they are doing their best to minimize the damage, which could come in the form of a delay in disbursement of the loan. So if you plan to use FM clause, you need to start building up your evidentiary trail of what actions you have taken to mitigate the damage. The sixth and last element is whether there is a duty to discuss in good faith to try to minimize the impact of the loss and damage. Now, in the examples that we have, we saw that in the sample aircraft procurement contract, and of course the sample construction contract. Now, the idea of having a good faith discussion clause, to me, it's quite fair in that it prevents parties from unilaterally terminating, and it gives parties a chance to seek a mutually beneficial outcome to a difficult situation where neither parties are at fault. So the question again is this a legal requirement? Now, the answer is no. It is not part of the prerequisites to enforce an FM clause. Yeah. But even if it is not expressed in the contract, I suppose if the parties value their business relationship with each other, there is always room for a good faith discussion. So this wraps up our discussion on FM. Next slide, please. So now we look at the difference between FM and MA clauses. We get asked from time to time the difference between FM and MA clauses, when to use either, or perhaps even can both be used in the same contract. So generally, and this is the philosophy behind it. Now, FM clauses seek to either terminate or postpone the performance of an obligation. It tends to be slightly more subjective, applies to a broader set of circumstances. So that is why the law provides for a few hoops to jump before you can enforce it, such as requirement for notice and mitigation. Now, who would use this FM clause? It would be people like suppliers, sellers, right? Whereas if you're on the other side, the counterparty, you're a buyer, you will push back against a wide FM clause. So that is a point of negotiation. Now, in contrast, MAC clauses tend to deal with a specific scenario of ending a contract because the situation has become untenable. And the situation or event tend to relate to financial or business disruption. So it's a bit more objective, if you will. Now, the key difference of FM and MAC clauses is therefore that notice and duty of mitigation is not prerequisites to triggering a MAC clause. Who would favor a MAC clause? Well, buyers would favor a MAC clause, right? Whereas the seller will push back against hair triggering a MAC clause. That is also a point of negotiation. Now, can you have a hybrid? Now, one way of looking at this is that material adverse change could be part of an FM clause. One of the events, one of the triggering events. But this means that it is subject to the same rigorous condition of how you are going to enforce it. Does it really help the seller? Not really. Yeah. The buyer may not want to use it as well because it becomes more restrictive than a standalone MAC clause. So that is why, by and large, you may find that FM and MAC clauses are rarely found together in the same contract. So now we move on to look at the components of a MAC clause. Next slide, please. Now, the key components of a MAC clause is as follows. The first element, which is also the most important one, is the triggering event. And as I have mentioned, the event tends to relate to financial situation. Now, in the case of a sale and purchase of either shares, business, or assets, right, it is typically set out as a CP or a condition precedent, which means it is something to be fulfilled before the completion of the contract. And it is worded in a negative, that is, it says no material adverse change has occurred. Now, increasingly, I have seen material bench, let me rephrase. I have seen this materiality benchmarked against a number. For example, diminution of asset value of the target by, say, 15%, 20%, right? So the percentage is something that is mutually agreed between the parties. Therefore, this clause is very objective. Yeah. In the context of an underwriting or subscription agreement. So quickly, If a company wants to raise funds through equity or debt issuance, either shares or bonds, right? The contract with the underwriter or the joint managers, as the case may be, would typically contain a condition precedent that no material adverse change has taken place before their obligations kick in. Yeah. So typically, MAC clauses for these agreements do not have a financial threshold like the 15-20% that I've just mentioned. It is, however, not fatal. Yeah. In this case, what is material is a factual test looking from the perspective of a reasonable bystander. And therefore, this can be benchmarked, against statistics, precedents, and things like that. Yeah. Now, in addition to a condition precedent, underwriters and joint managers would also include material adverse change as part of the event of default clause, meaning that at any time, regardless of whether all the CPs or the conditions precedents have been met, they can actually terminate if the conditions are met. Yeah. So that brings us to the second element of a MAC clause, which is which party seeks relief. Now, for most M&A situations, like I've mentioned before, the buyer would want to use MAC clauses as a way of exiting. Now, you may find that there will be a pushback from the seller in the form of ensuring that the financial threshold is high enough so as to avoid a hair trigger or an accidental trigger. Yeah. For underwriting and subscription agreement, if it is a CP, it is available to both parties. Sometimes you could be in a situation where even the issuer themselves find that it is not tenable to proceed with an issuance because that would affect the market price, right? But if it is an event of default, then it is available to the financial institutions. The third and last element is the intended consequence. Whether fortunately or unfortunately, there is only one consequence with respect to MAC clauses, typically, which is termination. So in this sense, MAC clauses are not used widely. Those with material thresholds would also have a relatively high bar to avoid hair trigger. Now, of course, that said, it does not mean that even though the only consequence is termination, the door is not opened to good faith discussions also. Yeah. So before I end, I just want to caution that this is, of course, a general discussion. It is likely that in each of your cases, you will encounter different situations where, for example, you may need to look beyond the four corners of your document and consider all other communications that you may have with your counterparty. So that concludes my overall discussion. Back to you, Hui Lin.
Thanks, Wei Hong. I think these are very useful pointers on how we can examine these clauses which we already have in some of our agreements. And this should also give us very valid prompts on what we need to do to be able to successfully rely on such clauses. I think one other takeaway is that communication with counterparties currently is very key during these challenging times. Before moving on, we have a couple of questions which we will ask our speakers to address at the end of this webinar. So do keep those questions coming. For now, I would like to invite Stephanie, who will talk about representations, warranties, and indemnities in your current transactions, how to use them effectively, and maybe, Stephanie, you can also address what are the additional measures that you can take in a transaction, whether you're a buyer or a seller.
Thanks for the introduction, Hui Lin. Good afternoon, everyone. Okay. I think we have heard from our two earlier speakers on how COVID-19 could have a significant impact on how parties view and negotiate contractual provisions. I think particularly force majeure clause that could potentially excuse performance or terminate an agreement. Notwithstanding this, I greatly believe parties should also consider the use of contractual reps and warranties and indemnities to help address the impact of unexpected circumstances such as COVID-19. But before this, I would like to provide all a brief introduction on the concept of reps and warranties and indemnities, and to deep dive into the impact of COVID-19 on these provisions. So as you can see, from the first slides, as many of you are aware, reps and warranties are statements of facts, which, if falsely given, can give rise to claim for damages under notional misrep, under tortious law, and breach of contract, respectively. It is also a very great tool used by parties to elicit important information from each other. On the other hand, indemnities are undertakings given by one party to another to reimburse the party upon occurrence of an agreed event, and are not dependent on having to prove that loss or damage is foreseeable. So with the current COVID-19 outbreak, we all know that the impact on these provisions is quite apparent on any contracting party, regardless of whether you're a buyer or a seller in a corporate M&A transaction, a tenant in the tenancy agreement, or a borrower in the financing arrangement. Now, let me share with you the four main impacts that I can think of. The first being, we learn that contractual parties are now forced to relook at given representation of warranties. This is because some of these provisions are becoming untrue. Now, this can be seen in an ongoing M&A transaction whereby the seller has represented and warranted in the SPA that since balance sheet date, there has been no material adverse change in its financial position. This R&W will be repeated upon closing. Due to the COVID-19 outbreak, the company's financial position has been badly affected. And in these circumstances, should there be no avenue for subsequent disclosure in the SPA, the seller would definitely be in breach of the said reps and warranties. Now, this leads to the second impact, where it might indirectly trigger the right to terminate. We all know for a fact that numerous contracts would include a term stating that a material breach of any given reps and warranties allows a non-defaulting party to terminate the agreement. Also, come to think of it, it might indirectly also trigger the material adverse change clause as well. As we have seen in financing agreements, it is quite common for parties to include reduced percentage of financial standing of a company as a material adverse event. And upon such occurrence, the other party has a right to terminate. The present COVID-19 outbreak, which has impacted quite a number of companies' financial standing, would likely fall within this unfortunate consequence. As you can see from the slides, another indirect consequence would also be the trigger of a right to claim for indemnities that would have been given. A simple example that I can think of, and thanks to Kuhan, would be, for example, a tenant has provided indemnity in favor of a landlord for any loss suffered by the landlord, for any breach of any given reps and warranties. We have seen that currently, many tenants are now struggling to pay rent due to inability to operate during the movement control order. And with this, tenants are now in a situation whereby they have to indemnify the landlord for not only the payment of rental, or for any losses, but for any losses that may arise from the non-payment. Moving on to the third impact, that will be the potential disputes on existing coverage on certain reps, warranties, and indemnities that have been given. So, for example, a seller in an SPA transaction has warranted that there are currently no proposals to terminate or vary the terms of the employee's employment agreement, except in accordance with applicable law. So currently, we see that a lot of sellers have been terminating quite a number of non-essential employees, or even vary the terms of those employees, such as instructing employees to take unpaid leave during the MCO. So potential disagreement may arise on whether such termination or variation is in accordance with the applicable law. And you ask me, why is that? Our Ministry of Human Resources, issued an FAQ recently stating that unilateral imposition of unpaid leave is not allowed. But somehow, as what I can see, the Malaysian government has provided a tacit recognition on employers putting workers on unpaid leave by providing these employees cash assistance. So this is one of the examples that I can think of that may lead to disagreement on whether something has been done in accordance with applicable law. Another possible impact, and the last impact that I would like to share, would be that agreed contracts may lack protection for some of the contracting parties. One notable example in M&A transaction, the SPA provides for indemnity in favor of a buyer should there be a termination of, let's say, top 10 supply contracts due to breach of provisions in those contracts. Due to the COVID-19, some of these supplies are forced to shut down, and the buyer will not be protected by the given indemnity. The reason is because this does not relate to breach of any contractual provision, but rather they are forced to shut down due to bad business. So what's next? So this move on to my next slide, which is to talk about enhanced measures. Due to limited time, I'm only going to focus on enhanced measures for ongoing and future M&A transactions. So let me start with the sellers. For ongoing transactions, sellers are encouraged to check on given reps and warranties and indemnities to ensure that they are not breached. And if so, to consider providing disclosures at closing. This is because most of the SPAs will contain a bring down of reps and warranties at closing. But if you ask me, what if the current SPA does not provide for subsequent disclosure? My recommendation would be for sellers to take the opportunity to negotiate with the buyers, to enter into a supplemental agreement, if possible, so to ring fence warranties most relevant to COVID-19 risks. With that in mind, and during the negotiation process, sellers could also start introducing appropriate materiality limitations and more awareness qualifications perhaps. So this approach can also be taken for future transactions as well. Secondly, sellers are also encouraged to introduce exclusion for losses arising from or relating to any business interruption or business downturn arising from COVID-19 or any other similar kind of situation. This, however, would greatly depend on whether the transaction involves reps and warranty insurance policy and whether the insurer is willing to cover for losses arising out of the COVID-19. But I think on this point, I would leave to my fellow partner Indahani to elaborate further. Let's move on to the buyer side. Buyers, on the other hand, should start to insist on specific warranties, financial position, business contingency plans, and other relevant areas of the target company. So this strategy alone provides, I can say, two notable benefits. The first being, through the request of such indemnities and reps and warranties, they can learn more about the exposure and as well safeguards of the target company has in relation to the COVID-19 outbreak or any unexpected circumstances. Secondly, it provides added protection to the buyers to know that the buyers are well protected through this enhanced indemnities and warranties. I think I better stop and let Indahani to continue. Back to you, Hui Lin.
Thanks, Stephanie. That was very useful. For the next part, we would like to call upon Indahani, who will talk to us about how to future-proof your transactions.
Thanks, Hui Lin. Hi, everyone. I hope everyone's keeping well and safe and also sane in this very strange environment that we're living in now. Okay, for my part, we are talking about, I'm mainly going to focus on M&A transaction. The first part, I will be talking about the impact of COVID-19 on current deals. It will mainly be focused on existing deals. And on the second part, I will talk about some of the factors that we should consider when we look at deals that are in the foreseeable future or even those after that. Okay, so let's move to the next slide, please. Okay, on the impact of COVID-19, I think I'm just going to briefly go through this. I'm sure a lot of you are also well aware of this. Of course, number one is there is a slowdown in M&A activities. For existing deals, they are either extended or they are temporarily suspended simply because the focus, and I think we all know that this COVID-19 just hit us really bad and really fast. So the immediate focus of most businesses would be on addressing the immediate impact as opposed to looking at expansion. So that is something that is a factor in the slowdown of M&A activities. And this is not just in Malaysia, not just in Asia. I think it is something that is felt all over the world. The other one is, of course, it is now a buyer's market. A lot of the business are affected, severely affected, and I think it will take time for things to settle. So for sellers who are very motivated to sell, they would really have to, I suppose, accept the terms dictated by the buyers. And on this point also, let's move on to the impact on valuation, because that's related to the fact that it is a buyer's market. So of course, valuation will be affected. For existing transactions, we would expect to see parties going back to discuss valuation, and the seller would definitely need to show that the impact of COVID-19 is minimized for the valuation. So there might be some going back to discuss the price and the value of the company. So that may be a bit prolonged now, because it's quite a challenge for now to look at the long-term impact, because this is something new to everyone. The other one is impact on investment structure and terms. The buyer would definitely want to look at whether the seller can stay on and how the business can be sustained. So in most cases, I would think that they will look at key personnel staying on in the business to ensure that a lot of the impact can be addressed and minimized. Succession plan, and also the other one would be in the event that the contract allows for maybe a performance milestone or earn-out mechanism. That is something that the buyer would definitely want to pay more emphasis on. The other impact is, of course, the timeline itself. A lot of deals are extended because of the closure of government offices in light of the MCO. Now, the MCO has been extended. We don't know whether it's going to be further extended. We hope that, we hope that Raya will be something that can be as normal as possible, but we'll see. So with the closure of government offices, this would have an impact on your CPs, especially where you need approval of regulatory authorities. And I would think that even after the MCO is lifted, there will be some backlog. So we will expect some delays. The other one is for a bid process, for example, I think we should expect some delays also. Even if it is done via a VDR, there will be some issues. For example, if the VDR itself is being set up during the MCO process, a lot of the physical documents would have to be scanned and uploaded onto the VDR, and with the closure of all offices, it may be difficult to get access to those documents. The other one is for bid submission itself, for example. There may be some issues in convening board meetings to get approval for bids and things like that. So that's the timeline. The other one is more of a practical impact. That would be the deal method itself. And I think we'll touch about this later when we talk about future deal. But of course, deal method will change. It is now mainly VDR. And also meetings are all conducted by video conferences via Teams or Zoom. And we will also touch about this a little bit later. Okay, so next slide, please. Okay, so on future deals, things to consider for moving forward in deals probably in the foreseeable future and also moving forward. And I've actually separated this into 4 buckets, and we will be talking about the structure first. For the structure of the deal, let's look at it from the perspective of the buyer, and then after that, from the perspective of the seller. For the buyer, it would be, what's important is to ensure that there's enough working capital post-deal. So I think with the buyer, they would want to try and retain cash as much as possible, just so any immediate impact of COVID-19 can be addressed. So on that note, I think from a buyer's perspective, and we're looking at structure, it will be mainly probably looking at preference for completion adjustment, because to take into account the impact on the valuation of the company. The other thing that the buyer would probably push for would be deferred or staggered consideration, again to address the immediate impact of COVID-19, and more emphasis, which Stephanie has touched on earlier, on indemnities and warranties for valuation. The other one would be to look at earn-out mechanism, simply because you would want to try, and this would be in cases where the seller actually retains some form of equity and control and management of the company. So they would want to ensure as much as possible the future performance. On the seller's perspective, I think number one is really to minimize the impact of COVID-19 on the target business. The seller would definitely need to be able to show and prove to the buyer that there will not be a lasting impact of this on the target business. The other one is, I think, of course, preference for a clean exit. And this would be in cases where the buyer are not retaining equity, so they definitely want to try and see whether they can get clean cash and then go and retire in the Caribbean after the whole MCO is lifted. So that's on the seller's perspective. The next bucket that we'll be looking at would be on the due diligence exercise itself, and this would be separated into two. One would be the logistic issues, and the other one would be the focus on duty questions. So on the logistic issues with this whole travel restriction and social distancing, that's going to be a bit of a problem. For factory tours, for example, how do you conduct a factory tour? And as a buyer, especially a foreign buyer, I would definitely want to see that the factory that I'm buying is actually there. So that is something that we probably need to figure out how to deal with it. Because even after the travel restriction is lifted, I think it will take some time for people to comfortably travel. The other one would be for management interviews, for example, but I think this can be easily resolved by video conferencing. The other one would be negotiation of the transaction document. Again, it will be, I think, done by video conferencing. For duty exercise itself, it will be mainly VDR. VDR is actually quite common nowadays, and I think most of our junior lawyers now hardly need to go to any physical office, to any client's office or target's office for physical duty. It's all done mainly by VDR. So that is something that we're all quite familiar with already. So I don't think that will be a significant impact on a transaction. So those are the logistical issues. The other one would be the duty focus itself. So for the duty focus itself, we would expect to see more questions relating to COVID management, your business continuity plan, how do you deal with employees working from home, for example. how do you deal with privacy breaches since your employees are working from home? And can there be a smooth transition from your office to home? So that is something that I think the buyer would definitely be asking these sort of questions, business continuity plan and things like that as part of the duty process itself. And I think the last part would be, of course, more focus on what Koo Hen and Wee Hong has spoken about, more focus on FM clauses, Mma Clauses, and termination provision in your contract, and this would be as part of the contract review. The next bucket, next slide please. The next bucket that we're looking at would be on documentation. For documentation, I think this one is we'll be talking mainly about the SPA. I think we should expect some delays, especially when formulating the SPA when we're looking at the stop date and the long stop date, because of the closure of government office, and after that there'll be some backlog. So that is something to consider in the SPA itself. The other one is something that Wei Hong has spoken about, which is the Mma clause. As a buyer, you would want to be able to kind of have an exit in the event of a material adverse change. But from a seller's perspective, how do you minimize and how do you formulate the Mma clause to exclude things that are not within your control and things that are not related to how you run the business itself. So these are things to consider. The other one would be what we call the conduct before completion. And for those of you who are not familiar, conduct before completion is basically when you sign an SPA, there's always a delay from the point of signing to the point of completion because you have to go and fulfill the CPs and all that. So because of this, there's always a list of items in the SPA where the seller can still have control over in the business, and this would usually be related to matters, day-to-day operation of the business. In some cases, the seller would have to go back to the buyer to get approval to do certain things. So for this, I think from a seller's perspective, what is important is to ensure that the seller has enough flexibility to take immediate action, especially for time-sensitive matters to address the impact of COVID-19. For example, if you need to terminate a supplier's contract and enter into a new contract with a supplier, I think these are all quite time sensitive. And if you have to go back to the buyer every time you make this decision and the buyer takes some time to get back to you, this would definitely have an impact on your day-to-day business operation. The last point would be on warranties, which Stephanie has spoken about. What can the seller comfortably provide? I think on this point, some of the warranties that we have seen in current SPA, which relates to compliance of laws and all that, do have some relevancy with COVID-19, but really it's just to go through the warranties to see what can the seller provide without, in light of the impact of COVID-19. The last bucket that I will be talking about would be on W&I insurance, warranty and indemnity insurance. This is something that is becoming quite common nowadays in a lot of transactions, and I think in Malaysia we see a lot of the W&I insurance being taken up mainly by the buyer. For W&I insurance, if you want to know how it works and if you're not familiar with this product, feel free to contact me. For us, we would usually advise in the transaction, we would usually advise the buyer, what do you need to do in terms of taking up the W&I insurance. We also advise the insurer itself in the whole underwriting process. So we get to see it from both perspectives. But I think if you want to talk about W&I insurance, that will need to be a separate topic altogether. But just on the part on future deals and what are the things to consider in W&I insurance, we would expect to see insurers as part of the underwriting process look at the adequacy of the buyer's duty into some of the impact of COVID-19 on the target business. So this would be on, business continuity, this would be on your supply chain, and this would be how your business has been affected because of this, and also the health of your termination provision and your FM clauses in the contract. The other one would be the insurers would definitely want to see seller's disclosure of the impact of COVID-19 on the target business. And on the policy part itself, on the W&I policy, I think the question is it a known risk? If it is a known risk, then chances are it will be excluded from policy, so the buyer will not be able to claim for related losses. And I think moving forward for W&I policy and insurance, I don't know. I mean, I think that the insurer would probably be looking at specific exclusion relating to COVID-19 or similar event in the future. But because at this stage it's still quite new, so I think it remains to be seen whether it will be a common trend and whether this will be something that we will see in most W&I insurance policies moving forward. So I think that's all for me. I will hand this back over to Hui Lin. Thanks.
Thanks, Hani. Okay, we're very conscious of time. It's supposed to be a Q&A session at the moment, but we only have 2 minutes left. So I think we will wrap this up. We have received some questions on law reform, contractual relief, frustration, the role of lawyers in M&A deals, and also questions on what are the other measures that you cannot rely if what are the other measures if you cannot rely on an FM clause. So for those of you who have asked questions but have yet to receive an answer, we will follow up on such questions if you have provided us with your name and contact email. You are also welcome to connect with any of your relationship partners within the firm. So to wrap up, today we have learned about how to utilize the various clauses that you have in your contracts, such as FM, reps, warranties, indemnities, and material adverse changes clauses. We have also addressed the question of what happens if you do not have such clauses. Hopefully this will provide you with a clearer picture of what to look out for when you go through your agreements. Now, we would like to thank our speakers, Kuhen, Wei Hong, Steph, and Ida Hani, for preparing the slides and sharing your insight with us. We would also like to thank all of you who have tuned in to our webinar on this warm Wednesday afternoon. For those of you who have joined us late, we do have a recording and slides will be sent to your email, so watch out for that. We also have a COVID-19 resource hub available on our website, and that will also be shared with you. We had a height of about 170 attendees today and maintained at a constant rate of about 140 attendees. So thank you very much for joining us. We would like to remind everybody that ZICO Law is present in all 10 of the ASEAN countries. If you do have any questions about doing business in any of these countries, please also feel free to reach out to us. Now, our next week's session is brought to you by our ZICO Labs teams, and it's called Regulatory Trends and Opportunities for Startups and Scale-Ups Post-MCO. Many businesses were unable to prepare for the impact of the COVID-19 pandemic and the subsequent operational limitations imposed during the MCO. Those that have braved this uncertain period would have to quickly adapt to what is being called the new norm. So for next week, we have a panel of speakers from ZICO, Futurize, and MDEC, who will be sharing their perspective on emerging industry growth areas together with their corresponding regulatory framework in order to better assist small businesses to prepare for life post-MCO. Till then, take care, stay safe, and stay healthy. A blessed Ramadan to all of those who are observing. We'll see you next week.